House to Home, presented by RE/MAX Diamond Realty.
We are back at it again. Liz Duenas from RE/MAX Diamond Realty Guam and attorney Mickey Flynn, an expert in the area of wills and trusts and setting up everything that you need to do as part of your real estate transaction. I mean, it's not on the books that you necessarily have to do this. It should be, though, because this is going to save you time, money, and probably a lot of stress going forward. So, Mickey, a pleasure as always.
Thank you, Jason. Thank you, Liz.
All right, Liz, buenas.
Well, we wanted to check with Mickey about how the process of probate, the expense associated, so people have an idea of what is involved with that. And if, of course, that's probably after the fact, but if before anything happens, what could be done to avoid having to go through that process? If you can explain, Mick, we'd appreciate it.
Sure. So probate is simply an administrative process which is overseen by the court to ensure that the law is followed and to ultimately transfer assets that are in the name of the estate to the rightful creditors and heirs. So when you die, you can't come down from heaven, or if you're an attorney, come up from hell and engineer how your assets will be given or transferred. So whatever plan you have in place, or if you don't have a plan, then the probate code takes over, and the probate code will dictate how the probate is processed through the court.
Very good point. That's not the type of transference we're talking about, is, being reincarnated. That kind of thing does not exist in real estate.
Yes. So unfortunately, I can't give you advice on that area, right? But with respect to probate, it's not always a bad thing, but you may be shocked with some of the aspects of probate that you didn't know about. And so for some people, once they get over that shock, then they, as Liz, you've indicated, want to do some planning to avoid that shock for their loved ones. The things that you might do would, again, depend upon, as I mentioned previously, on your goals and your objectives. So I always have clients consider 5 possible approaches that they can take to estate planning. What I call 1, the do nothing plan or default plan, where you simply end up in the clutches of the probate code and the court. And then number 2 is what I call the giveaway plan. Number 3 is what I call a contract-based plan, where you engineer your assets in a form of what I call contract arrangements, so that the assets pass to loved ones or to beneficiaries outside probate. Number 4 would be what I call a will-based plan. And number 5 would be a trust-based plan. So again, each of those types of planning vehicles would depend upon your goals and your objectives. And they will each have some pluses and some minuses associated with them. So you need to consider 1, your goals and objectives, and then 2, the pluses and minuses of each approach to ultimately determine which plan will be best for you. So necessarily, if you've done nothing, then the probate code will take over. And with respect to your assets, they will go through the probate process. And that is, of course, plan number 1, or the do nothing plan, or default.
And I've been through that one myself.
Okay. So if you were doing it personally, it might have been somewhat torturous. If you were standing outside as a family member, then you just may have been in sort of bewildered and wondering, wow, how come this doesn't go so quickly, or how come we're paying all of these fees? it can be aggravating for the person who's involved and then bewildering for those who are on the outside, family members. And then the other one of the other vehicles that I mentioned, the will-based plan, is for some people, there is a misinterpretation or misconstruction of what goes on when you've created a will. And I simply call a will a love letter to the judge, which means that you are definitely going through the probate process if you have assets in your estate and you have a will in place. So some people have the misimpression that, oh, I established a will or a will and last testament, and now all of my work is done. They dust their hands, and that may work well for them if in fact it meets all of their goals and objectives. But if one of their goals is to avoid the probate process, then the will not do that. So again, we go back to the goals and objectives that you need to identify first with someone who can help you do that, and then to a weighing up of the pluses and minuses associated with each possible estate planning vehicle.
So for example, so if I do a will and I've got 6 kids, and in my will I state each of them get one piece of property, it's a direction for the judge to make sure they each get that piece of property versus all of them being tied to every single piece of property. Is that correct?
Right. That may be a plan that someone has in mind, and they want to make that take effect through a will, and they can do that, of course.
And then the judge will follow through and honor what was in the will.
Assuming that everything is in order, the establishment of the will was done correctly, the will is bona fide, then ultimately it generally will take some time, I'd say at least 10 months. We've had probates without wills or with wills, it doesn't really matter, that have gone on for 70 years on Guam.
Ooh.
So, that may be an approach that you want to take. It may not.
How is that in terms of timeline, Mickey? How is that shaping up today? Because of course, we as a society are trying to slowly inch back to the way of life that we used to enjoy pre-2020. And, of course, the courts are trying to get caught up with like their caseloads and everything like that. So I'm sure, if you have like a probate matter and everything like that, those aren't exactly like top tier as far as a priority and everything like that. So those get bumped off, right? What are you seeing as far as the time for probate cases to be resolved?
Yeah, in my practice, I try as much as possible to stay out of the court. But I found the courts during this pandemic to be very hardworking and accommodating. And I did have a couple of probates that went forward and were addressed relatively quickly. And I think at least one of them within that general 10-month time frame. There are some statutory requirements that necessitate the time frame. So there's a notice period that's required under the statute. And this notice period is for the petition for the executor or administrator to become appointed by the court. And there is a period where creditors have an opportunity to assert a claim against the estate. And so these these windows allow for people to, from the outside, to investigate and consider what the probate is about. And so that's why it can't be shortened, to a couple of weeks time frame, but rather you're looking at fairly relatively month-long time frame for concluding a probate. Yeah.
I'm glad we're talking about this, Mickey, because some people think that when there's a will, they automatically get the piece of property, but that's not the case. The will
Right.
is just direction, and it still has to go through the probate process. And I like what you said, the giveaway. So prior to that, it's best that we give the property to the heirs prior to anything happening. Is that the giveaway you were talking about?
Right. And that may be the case for some people, depending upon their goals and objectives, but they have to then think about the possible goal and whether this is an important goal for them of retaining control during their lifetime. Because once you give it up, then of course you have no legal recourse to get it back. So there are pluses and minuses with each approach. And that's, I mean, one of the pluses with the giveaway plan is, okay, you give it all away, then you have no estate. And of course, your loved ones don't go through the probate process. But on the other hand, if you give it away, that's it. You need assets to go to fly out to the Philippines for medical care and attention and treatment. And there aren't any. You've given it all away.
Well, if I can
So
just end with maybe this sentiment, Mickey, what you've educated me and hopefully all of our viewers is, of course, you put your heart and your soul into these real estate deals, or even if it's been, property that's been bequeathed to you and everything like that, you're essentially doing a disservice to that asset if you don't properly cover yourself in this regard. Like, especially if you'll be passing it down to people and everything. So we really appreciate the information, and everybody, please make sure you take care of this. It's something that absolutely has to be done. So Liz, Mickey, thank you very much, both.
thank you, Jason and Liz.
All right. And thank you very much for watching, everybody. We'll see you next time right here on House to Home.